Hello, everyone. I'm Matthew Bloom from Pekin Hardy Strauss Wealth Management, and I'm here with my colleague, Erin Kelsey, to talk about our most recent Navigator, which is about the Secure Act. Now, Erin, we actually already wrote a Navigator about the Secure Act, so tell me, why write another one on the same topic?
Sure. So we wanted to revisit the Secure Act, but spend a little bit more time talking about one particular provision of the Secure Act, which has pretty significant implications for owners or beneficiaries of large IRAs. And we just wanted to devote a little more time to that. For a little bit of context, before the Secure Act, if you inherited an IRA from someone who wasn't your spouse, you were able to take distributions from that IRA over the course of your own lifetime. So, especially if you were someone who inherited an IRA from a parent, this could be pretty beneficial to you because you would have a really long time horizon to take distributions from that account. You'd be sort of spreading out the tax burden. And this was generally a good thing for people. This was known as the stretch IRA, which people might be familiar with. The Secure Act basically says no more stretch IRA. If you are a non-spouse beneficiary of an IRA, you now have 10 years to take that distribution. You don't have to take it in any particular order or amount. There's no schedule, but it has to be done in 10 years. So this is something that can have pretty significant tax impacts for people who are inheriting these large IRAs now that this is in place.
Mm-hmm. So given these rules, what should the owner of a large IRA do if he or she wants to try to minimize the impacts of these changes?
Fortunately, there are quite a few options for people now that really will depend on, kind of what makes the most sense for your situation. We talk about a bunch in the Navigator, but you have options for things like changing how you set beneficiaries on your IRA, especially if you're someone who's married and you're passing IRAs to your children. You could potentially convert your IRA to a Roth IRA to pass to a child, because those come with sort of fewer strings attached from a distribution perspective. And if you're someone who's interested in doing some charitable giving as part of your estate planning, there are some interesting options available in terms of either directly donating your IRA to charity, or there's a charitable trust structure that lets you essentially almost mimic a stretch IRA and provide income to a child or a relative while also making a donation to charity. We talk a little bit about all of these things in the Navigator and some other ideas, but this is something that's really going to be dependent on sort of your financial situation, your heirs' financial situation, and what your goals are when it comes to estate planning. So I'd encourage you to read the Navigator, kind of get the overview. And then if you're one of these people impacted by this, I would really encourage you to talk directly to your portfolio manager to discuss what might make the most sense for you.
Got it. Well, it certainly sounds like there is some very helpful and actionable advice in this Navigator. So I do encourage anyone who might be impacted by the changes brought on by the Secure Act to definitely give it a read on our website at www.pekinhardy.com. Thanks a lot.